I'm a staff attorney with the Georgia Justice Project. I was a criminal defense attorney for about 10 years, and I've been here for about 3. And I'm joined today by Jalissa Hobbs, who is an intake specialist with our office. And Jalissa is going to be supporting with questions. Just a couple preliminary. First of all, congratulations. We know that you're here because you or a loved one has some kind of criminal record, and this is your first step that you're taking to try to better your life for housing, employment, licensing, etc. So welcome, congrats on taking this step. A couple preliminary rules. Please use the Q&A box to ask general questions. Please do not put any personal case information or provide details. Of course, now I need a sip of water. Or provide case details about your specific case. This is to protect your privacy. Please ask your questions as they arise in the Q&A, and our intake team, Jalissa, will answer it in real time. We do have a few pop quizzes today, which is funny because this is a webinar, and so we can't actually hear you. But we want to make sure that you're understanding what's being said. So if we ask a pop quiz, answer, give your answer in the chat box. And don't feel like you have to write everything down. This is going to be sent out in a PDF format. There's a lot of text on some of the slides, especially at the end, because we wanted to give you a lot of examples. So you can't possibly capture it all now. Just know that it's coming in your email. Okay, let's jump in. Who are we? The Georgia Justice Project is an almost 40-year-old nonprofit law office. We're located off of Edgewood Avenue. I'm on the criminal records team. Our organization does a lot of different kinds of work to advocate for folks like you and those you love who are being negatively impacted by the criminal legal system in some way. This work includes advocating for changes in the law, holistic criminal defense. We just do that in DeKalb and Fulton, prison reentry and support, helping folks with driver's license suspensions, petitioning the court to end lengthy probation sentences, and, of course, the record clearing work that brings y'all here today. Our policy work does involve advocating for more record clearing options. I just want to acknowledge that record clearing is still pretty limited in Georgia, and we think that everyone deserves a second chance. We've already had a lot of success changing the law and making it better, and we hope that it will get better in the future. So if you listen today and you don't hear an option available to you, just know that we're not done changing the law, trying to get it changed. Okay, let's talk about a record clearing worker, which is why you're here. This falls into a few different categories. The first thing we do, we represent clients who can't afford a lawyer for free. We also provide self-help resources for folks who want to try to clear their own record and tell their own story in a way that supports them for getting that relief. And we work to change and improve the law at the Capitol, as I mentioned. So I just want to say one thing up front. I start with all the hard stuff, and then I'm going to get into all the good stuff. For those of you looking to have a lawyer assigned to clear your record, we're going to tell you at the end of the presentation how to do that. However, I want to manage expectations here because GJP is a very small nonprofit. Most of you on this call are going to learn about how to do this yourself. You're going to get self-help and community resources, links, scripts, and samples for how to approach doing this. Just to give you an idea, most months we have over 100 folks on this presentation, and our criminal records program takes often around 10 applications a month. That's not the same every month, but give or take. So that just kind of gives you an idea of how few slots we have for direct representation. So don't lose heart. There's a lot you can do on your own to clear your criminal history, and that's what this presentation is designed to do. It's designed to empower you and make sure you walk away feeling educated and informed about what next steps are possible for you to do on your own. And of course, when you hit roadblocks, GJP is here. We're going to give you contact information so you can reach out with questions. So last negative Nancy slide, and then we'll be moving on to the good stuff. So this is what don't we do? We do not offer representation for folks with records outside of Georgia. So if you have a Florida record or a South Carolina record, there are some resources that you may be able to find to help you, but we don't do that work. We also don't represent folks whose main concern is getting their firearm rights back. This is absolutely a side benefit, and this is something that you can do, but if that's your primary issue, is wanting your firearm rights back, that's not something that we help with. We do not help folks with federal records or with federal pardons. We don't support folks who were wrongfully convicted or who have innocence claims. There's the Georgia Innocence Project, the National Innocence Project, but that's just not work that we do. Or folks who are wanting to appeal their case, have the case outcome overturned. We don't do that work. We also don't represent folks who are concerned about immigration consequences. So let me be clear, we do represent folks who are immigrants, but if your primary issue for record clearing is you're worried about the immigration consequences, that's not our area of expertise, and we don't want to lead you astray there, so we don't do that. And finally, we don't assist folks with record clearing who have a pending case. So feel free to stay on and listen. I think even if you're outside of the scope of this, there may be some helpful info, especially at the end about how to tell your story, but just want to say that up front. All right, what are we going to talk about today? First, record clearing in Georgia. How does it work? Eligibility and process, meaning who can get it and how do you get it? Also, what's on your Georgia criminal record? People say this like everybody knows what it is, right? What's on your record? What shows up on your record? Like, how does someone get a record? What does it look like? What are the different kinds of records that exist? Then we're going to talk about how to tell your story. This is going to be really important, not only with record clearing, but also for folks who can't get everything off their record. This can be helpful for jobs and housing when you're applying for things. If you're going to have to talk about your record, how do we recommend doing that? Where have we seen people be successful talking about their record? Also, knowing your rights. Just want to flag here because it's not on the slide. But in this part, we're going to talk about early termination of probation and driver's license suspension. So if you think that applies to you, stay here. And then at the end, Jalissa is going to talk to you about how to apply for GJP services. Okay, record clearing in Georgia. Many of you have probably heard the term expungement. I think it's often what people Google, right? How do I expunge my record? Expungement means records are destroyed completely. You can deny that the arrest or the incident or the case ever happened. Expungement doesn't exist in Georgia. We have it in red and underlined there because it's really important that you know that. If you were ever arrested in Georgia, even if your case was dismissed, law enforcement, meaning police, criminal courts, probation, parole, jails, they will always be able to see your record. Okay, there's no way to completely destroy your record so that law enforcement can't see it. However, there's still a lot you can do to prevent other folks, employers, housing providers from seeing your record. In Georgia, the way that you clear a record is to limit who can see those cases or your record on a private background check, or on a criminal background check. In other words, the record of the case doesn't completely go away, but it will be hidden from view for nearly everyone except law enforcement. This process of hiding your cases on background checks takes two steps called restriction and sealing. Let's talk about what each of these two steps does and why you need both steps. So I misspoke before and said private background check instead of background checks. And the reason that that's important is because in Georgia, there's actually two kinds of background checks you can have run. Because when people say, what's on my criminal record? What they really usually mean is if somebody runs a background check on me, what's going to show up? So in Georgia, the answer is it depends which of the two kinds of background checks are being run. So let me tell you about the two kinds so that you understand. The first kind of background check that a third party can run is called an official government background check. It can either come from the state of Georgia or from the federal government. The official state of Georgia one is called a GCIC background check. You guys may have heard of that, Georgia Crime and Information Center report. The federal version is called an FBI report. Both of these government-issued background checks rely on information gathered at the time of your arrest for a fingerprintable offense. They're based on fingerprint arrest records. So if you're being fingerprinted for a job or for housing, it's rare for housing, but if you're being fingerprinted for a job, that probably means that the job is going to be reviewing an official government, either GCIC or FBI background check report. That's the first kind. The second category or type of background check is a private background check, the one I mentioned before. There are many, many companies in the United States that do these. Checker.com, backgroundchecks.com, Sterling, ADP, more than I can list here. These private background checks are not based on your fingerprint arrest records. Instead, private background checks rely on court databases, court records. They use your name, your date of birth, sometimes your social security number, but they're not using fingerprint arrest records, and they're looking at court records either online or they send runners to the courthouse. These court records exist in files at the courthouse or online. Okay, so that's a lot of information. Why did you need to know that? Because I mentioned earlier that there's 2 steps to clearing a record in Georgia: restriction and sealing. And the reason this exists is restriction, which is listed here on the left, is the name of the step in the process for hiding cases on your official fingerprint government background checks. So if you're trying to hide information on your GCIC or your FBI report from employers or housing providers, you need to get your case restricted. Sealing is step number 2. It's shown here on the right, and it's the name for the process for hiding court records used by private background checks. Okay, so when you're sealing a court record, whether pulling it down from offline or making it so that someone can't get it at the courthouse. And that means when private background check companies go to the courthouse or go online to find your records, they can't, so they don't report them. Why do you need to know all this? Because you never know what kind of background check is going to be run. You need to do both steps. We really encourage folks, even if you say, oh, I know I'm going to be printed for this job, I don't need to worry about sealing. It's just not a safe bet. Sometimes they'll run both. So sometimes they'll run a fingerprint check and a private background check. You just don't know in advance. So both steps are necessary: restriction and sealing. So as if I haven't hammered this home enough, I want to ask, pop quiz, if my criminal history is restricted, will it show up on background check reports? If it's just restricted. Has anyone been listening? Jalissa, what do you think? Has anyone been listening? What are folks saying?
I see a lot of no's. Oh, and I've been listenings.
I believe you. So if my criminal history is restricted only, meaning it hasn't been sealed, it's still going to show up on a private background check. So it was just a different way of asking, reminding you guys, you need how many steps? 2 steps, restriction and sealing. Because if you only get it restricted, that means it's going to come off your official government background check, but it's going to show up on private background checks. So I see someone raise their hand. Because this is a webinar, we actually can't answer questions live, but if you put your question in the Q&A, that's going to be the best way to get it answered. Jalissa will answer them, and I'm going to review it at the end. We're going to answer some out loud. Okay, so restriction and sealing, you need both steps if you take nothing else away today. So let's talk in a little more detail about record clearing in Georgia and how you actually do this. So you need 2 steps. What path you take to restricting and sealing your record is going to depend on how the case resolved. Because although you always need both steps, depending on which kind of case it was, there's a different path to getting to restriction and sealing. How the case resolved or how the case ended is called a final disposition. So that's something, it might be worth writing down. You'll have this presentation, but a final disposition is going to be a word we're going to use a lot, and it's an important one because it's the document and it's also the name for how your case ended, okay? So it matters, for example, was your case a felony conviction? Did you get a pardon and it's a pardoned felony conviction? Is it a misdemeanor conviction? Or is it a non-conviction? The case was maybe dismissed, or you received first offender and then that case was discharged successfully so that it's not a conviction. Or maybe it was a dead docket. At the beginning of each section, I'm going to call out the type of case that we're going to be talking about in that section, whether it be a felony conviction or misdemeanor conviction or non-conviction, so you can listen up to see if it applies to your situation. And I'm going to talk through each of the paths you take to get those different kinds of cases restricted and sealed. We're going to start with convictions. Both misdemeanors and felonies. It means if you have a misdemeanor or a felony conviction on your record, listen up. One thing I want to say first is that there's a lot of confusion about how long convictions can be reported on background checks. So before we jump in, let me make clear that under the law, convictions that have not been restricted and sealed may be reported forever. Okay, there's a lot of confusion. Some people think after 10 years they go away, after 7 years they go away. That is not true, okay? If you haven't had a case restricted and sealed, simply waiting for time to pass is not going to clear your record. So folks may have gotten lucky for example, they had a background check run and an old case didn't show up, that is usually because the employer is not paying for a lifetime background check. So maybe they'll just pay to just see felonies or just see the last 5 years. So that can be, a dice roll. You may get lucky, but legally, background check companies can report convictions for a lifetime unless you get it restricted and sealed. So I just want to make sure you guys know that that's not a safe way to approach record clearing. It's just to wait for time to pass. All right. What do we mean when we say conviction? This is probably obvious, but I'll just run through it really quick. If you took a guilty plea, that includes a time served plea. Okay. So even if you got time served, you didn't do any jail time or any prison time or anything. If you took a plea, a guilty plea, then that's a conviction. If you were found guilty after trial, that's a conviction. A no contest plea is also a conviction. I know there's a lot of confusion about that. But under Georgia law, if you took a NOLO plea or a no contest plea, that is a conviction that requires restriction and sealing. If you got first offender or conditional discharge and you were unsuccessful, meaning it was revoked, the judge adjudicated you guilty, brought you back in front of the court and said, we're taking your first offender, your conditional discharge, that is also a conviction. So we're going to start the discussion by talking about the two most powerful conviction clearing remedies in Georgia, which are retroactive first offender and the Survivor's First Act. Both of these remedies, these paths, these options, can be used on misdemeanor or felony convictions. And both options, if they're granted, means that your record is no longer a conviction under Georgia law. So in other words, if you get relief under retroactive first offender or survivors first, it means that your conviction will be converted to no longer being a conviction and the record can be restricted and sealed. These are also the two options that are best to have a lawyer. Okay, it is absolutely possible to do this without an attorney. I want to be very clear. People do this without a lawyer, but it is most helpful. If you listen up and you think these are the options that apply to me, this might be helpful to apply for an attorney. I'm going to talk about one at a time. So first, let's talk about retroactive first offender. This is a mouthful. We sometimes call it RFO. This allows you to go back in time on either a misdemeanor or a felony conviction and use your first offender, which means that it makes the case not a conviction under the law. A couple important things. You can only do this one time on one case. This means if you have more than one felony conviction, RFO is not the option for you, okay? So you're going to need to use it with another option that we're going to talk about, or maybe it's not a good option altogether. But if you have more than one felony, RFO is not conviction. RFO is not the option. It might be the option for you if you've never used your first offender before. And when I say that, I'm not talking about pretrial diversion or PTI or anything like that. If those are fine, if you use PTI, you can still use your first offender. But if you've used your first offender before, this is not available to you. It also might be an option if you were not informed about first offender at the time. So in other words, you didn't even know it was available to you. No, the judge didn't talk about it. Your lawyer didn't talk about it. If somebody told you it was an option and you said, I've considered that and I don't want to take it, this might not be available to you. It might be for you if you have no felony convictions prior to the case you're trying to clear off your record. And finally, it might be for you if your charge is not on the list of excluded offenses. So in other words, there are some cases, murder, rape, armed robbery, certain sex offenses, and DUI that are just not first offender is not available for those cases. So one thing to know is that in order to apply to get RFO, you have to ask permission from the prosecutor's office. This is part of why it's helpful to have a lawyer, because the law requires that you ask permission first from the prosecutor's office to request RFO. We really want this law to change, and we're working on trying to change it, but for now you have to ask permission. At the bottom of this page, you're going to get this in PDF. There's a link for a lot more information for you to read about retroactive first offender. The next option, which also applies to both misdemeanor and felony convictions, is available to individuals who've been the victim of sex or labor trafficking. Sex and labor trafficking, also sometimes called human trafficking, are defined very broadly under Georgia law. If you think that someone coerced or forced you into committing a crime, you may fall under this law. If you're not sure, reach out. We can talk through it. Unlike RFO, which can only be used one time, if you meet the criteria for the Survivor's First Act, you can have an unlimited number of convictions cleared if they were in any way connected with your experience as a survivor of trafficking. Also, if you think there's a chance this may apply to you, we highly recommend that you reach out to GJP for assistance. And we've linked here more resources, an organization called Street Grace that focuses on supporting folks who've been the victim of human trafficking. Okay, so we've talked about RFO, we've talked about Survivors First. Next, we're going to talk about pardons. So I'm going to do another listen up, listen up. If you have more than one felony conviction on your record, or if your one felony conviction is not eligible for retroactive first offender, let's say you already used your first offender before that, or maybe you lost your first offender on that case, right? You had it, but then you were adjudicated guilty. If you have more than one felony, if you lost your first offender, this section is for you. And this record clearing remedy is the main one that you're going to focus on. This is also, I'm happy to say, very possible to do without an attorney. Many, many, many people get pardons without the help of a lawyer. So listen up. What is a pardon? A pardon is an official certificate of forgiveness from the state of Georgia. They are reviewed and granted or denied by the State Board of Pardons and Paroles. It's entirely outside the court process, okay? There's this, you don't have to go into court to do this. There's a board that is put together, a state board, and they're the ones who make decisions. When you receive a pardon, your case is still a conviction, but the pardon can be really helpful for a few reasons. First, it demonstrates that you've been forgiven, right? The state of Georgia has determined that you've been rehabilitated. And even better than that, most pardoned cases are eligible for restriction and sealing so that they will no longer show up on background checks. Okay, so if you can get a pardon, and then that's step one is getting the pardon, right? You have that certificate of forgiveness saying you've been rehabilitated. That's helpful in its own way, right? To show employers and housing providers. But then there's the second step. You can go ask the court to restrict and seal that pardoned felony case. And if it does get restricted and sealed, it's not going to show up on background checks. Okay. So we have folks who have 3, 4, 5 felony convictions. They're old. Plenty of time has passed. They apply for a pardon. They get a pardon. They restrict and seal those pardoned felonies, and they're applying to jobs with a background check that says no record. All right. That gives you an idea. It's really powerful. Most of the people who get pardons get them for felony convictions. When you apply, you can apply for an unlimited number of felony convictions to be pardoned in one application. Although the board will consider some misdemeanor convictions for pardon, it's really rare and it requires exceptional circumstances. You can look at the website that we've linked to get more information. Really important things about a pardon: you cannot apply until you are done serving all criminal sentences for at least 5 years. Okay, so that's the hard piece of news here, is that you have, if you're still on probation, you cannot apply for a pardon. You have to get off probation and wait for 5 years. That's even if it's misdemeanor probation. Okay, so let's say you have a felony 10 years ago that you're wanting a pardon, but you're still serving probation on a misdemeanor, you just got off probation on a misdemeanor. You have to wait 5 years from the end of your last criminal sentence to apply for a pardon. There are ways to waive that waiting period in some circumstances, but again, you should check out the website. It's really rare. And if you get denied, you're going to have to wait another 2 years before reapplying. So we really encourage folks to wait that 5 years just to make sure you're eligible. So the pardon process overview. If you are planning to apply for a pardon, first you want to check out our How to Pardon one pager, which is linked at the bottom. It walks you step by step through the pardon process and how to apply for a pardon. Also, make sure that you review the Telling Your Story section of this presentation, which will come at the end, and try to follow the guidance given. We've really outlined where the kinds of stories that we've seen be successful. Of course, you have to tell the truth, right? But how to frame your story and your experience in a way that will be compelling to the board and that they will find persuasive. Okay, so let's say you get a pardon. You're not done. In order to have your pardon restricted and sealed, you need to go back to court where the case was prosecuted and file a petition, which is a written document requesting that the case be restricted and sealed. You need to do this for each separate pardon. So if you have a case in Cobb County and a case in Bibb County, for example, and all of them were pardoned in the same pardon, you will need to go to Cobb County to ask for that record to be restricted in court, and then go to Bibb County to ask for that record to be restricted and sealed. Also remember restriction and sealing. Most pardon cases are eligible for restriction and sealing. There are some really serious violent felonies and sex offenses, as well as DUI, that are not eligible for restriction and sealing after a pardon. So you want to check out our materials. We have the extensive list there. Wondering, if you're seeing any trends, Jalissa, or confusion about either retroactive first offender, survivors first, or pardons that you think I might be able to clear up confusion before we move on.
I see a few people in the Q&A and also in the chat have asked, what if their felony is out of state?
Good question. We do not handle out-of-state records. The Georgia Justice Project doesn't. So I will say there are organizations in other states that do help folks with restriction and sealing. I would recommend Googling expungement South Carolina or expungement Florida. Legal aid, if you're coming up empty with Google, I'd recommend almost every state has a legal, and sometimes they're in the cities specifically, has a legal aid organization. That is a good place to start. So if you don't know who to call, for example, in Florida, I'd look up legal aid, call the number or reach out to the email and say, I'm trying to get my record cleared. I'm trying to do expungement. And do you know of any organizations, or do you guys help with that? So I think many of you who have records, you know this better than I do, which is just ask and ask and ask again. And every time you get told no, find somebody else to ask, right? No can't be the end of the road. So just keep, but I'm sorry that I don't have more than that, but we don't handle out of state convictions. Anything else that you're seeing?
Someone asks, I have a record restricted under the first offender discharge, but I still need it sealed. Can I
Yes,
petition to have the record sealed without an attorney?
yes, yes. So you can. I would recommend that person email our intake to ask for a pro se petition. So you can, pro se, it just means you represent yourself, right? And so you can certainly apply to GJP and start with that. And then if you are not able to get that, then we offer sample pro se materials for you to petition for a successfully completed first offender to have that record restricted and sealed. Or excuse me, it's already been restricted, to have it sealed. So yes, and I love that you honed in on what you need. You're exactly right. It's been restricted because you were successful in first offender, and you need to petition to have it sealed. So if there's not anything else that's coming up a lot, maybe we keep going and then we can save some for the end. Okay, great. So we're going to move from felony convictions, which we've been talking about, to misdemeanor convictions. And this section applies only to misdemeanor convictions. Okay, so if you have a felony conviction, and only a felony conviction, this is not going to apply to you. But if you have a misdemeanor conviction, this is where you should listen up. Sometimes you're going to hear GJP lawyers call this remedy SB 288, which is a fancy way to say Senate Bill 288. That's the bill that caused this to be passed. But it really is just the law that allows you to restrict and seal a misdemeanor conviction. Our office helped get this law passed a few years ago, and it says that you can have up to 2 misdemeanor convictions restricted and sealed during your lifetime. Misdemeanor restriction and sealing might be for you if you already used your RFO, or you don't want to use it. You want to save your first offender for something. To qualify for this, it has to be at least 4 years since your last conviction. Okay. Any non-serious traffic offense won't affect the waiting period. So let's say you have a misdemeanor battery from 10 years ago, you're wanting to get restricted, and you also just took a plea for driving on a suspended license or for a speeding ticket or things like that. You can still apply to have that battery restricted and sealed so that the non-serious traffic offenses will not affect that 4-year period. But anything else, you're going to have to wait 4 years from the time of your last conviction. Also, there are many excluded offenses, unfortunately. So domestic violence cases, family violence cases, you cannot have them restricted and sealed under this particular option. Also, DUI, you can't have restricted under this particular option, and certain theft charges. Theft by shoplifting, you can have restricted and sealed under this, but certain other theft charges you cannot. We are working really hard to get this law expanded because we know that 2 is not enough. It's just not. We want there to be an unlimited lifetime number, but this was the compromise that happened when the law got first passed, and so we're hoping to expand it. So you would want to use this if you've already used or don't want to use your RFO, have more than 1 misdemeanor conviction, and yeah, that's it on the misdemeanor for eligibility. So what's the process for this? Let's say I want to do it. I want to have my 2 misdemeanors restricted and sealed. You have to file a petition with the court where your case was originally prosecuted. So similar to if you've gotten the pardon, you got to file a petition with the court. These cases can sometimes require a hearing where you need to tell your story to the judge and a prosecutor. If the court grants your petition, your case will be restricted and sealed. If your petition is denied, the case will remain on your record. We can also provide a sample petition on request. And if you're denied, there's a 2-year waiting period, but then you can reapply. I'm trying to think if there's anything else on this. With the hearing, we're going to give you some scripts and some options for how to tell your story again at the end. I want you guys to remember when you're doing record clearing, I don't know, but I can imagine that criminal court is a very scary and triggering place. Frankly, just having practiced there for 10 years and seeing the violence that happens, I don't like going back into criminal court. And so I can't even imagine if you were victimized there, how that might feel. But I want to remind you that on restriction and sealing and record clearing cases, there's not a threat of a cage. There's not a threat of another conviction. The worst that can happen is that someone can tell you no. Okay. So for those of you who feel kind of scared or panicked about the idea of having to go back into court, I just want you to know the worst that can happen is the judge throws the case out, right? You're the one asking for something. So it just feels important to say that. So for those of you who've heard all the record clearing options and think, well, shoot, I'm on probation. None of this applies to me, or it hasn't been 5 years, it hasn't been 4 years. Don't lose heart. We have a lot more info coming up that could be helpful for you and for you to advocate for yourself even as your records continues to show up on your backgrounds. So I'm going to talk briefly about non-convictions. Unlike convictions, non-convictions, we don't have to separate out into felony and misdemeanor because regardless how the case started, if it resulted in a non-conviction, the way that it gets handled is the same. So listen up if this section applies to you if you have any non-convictions. What is a non-conviction? This one, unlike convictions, is not as obvious, right? So what includes? Obviously, if the case was dismissed, null prost, not prosecuted, those are all non-convictions. Also, if you were acquitted after trial, not guilty after trial, that's a non-conviction. If you did PTI, pretrial intervention, and you were successful and then your case was dismissed, that's a non-conviction. I'm going to skip the county ordinance for a sec. I'll come back to that. But if you were successful on first offender or conditional discharge, the person who asked the question, they said, I got first offender and it was discharged. I was successful, which is amazing. That case is not a conviction. All right. So those are all non-convictions. That means this section applies to you if you have any of those. Also, I want to briefly talk about county ordinance violations. Sometimes you get arrested and go to municipal court, like Sandy Springs Court or Johns Creek Municipal Court, right? You're not going to a county state court, you're going to a municipal court. And you plead to what's called a county ordinance violation. Sometimes you plead to a state charge in those places, and those you have to do the misdemeanor restriction and sealing. But if you plead to a county ordinance violation, that is not a conviction, all right? You can use this non-conviction process. If you're not sure, you probably would know, probably your lawyer told you, hey, we're pleading this down to a county ordinance, right? But if you're not sure, that's something that you could go to that court and ask. So talk to the clerk, ask for the final disposition and take a look and see, was this a county ordinance violation or state charge? If it was a state charge, you need to use the misdemeanor restriction and sealing. See if there's anything else. Okay, yes. So uh, if you have non-convictions on your record, most of you will be able to manage record clearing on your own using this slide and the links on it. Okay, we have a lot of self-help materials available. We have a checklist available for folks who have non-convictions. If all you have on your record are non-convictions, you really don't need a lawyer, or you shouldn't. Obviously, I don't know everyone's situation. If you struggle with literacy or there's some other barriers, certainly there may be folks who need an attorney, but I'd say for the vast majority of people, non-convictions is something that you can handle on your own. The first thing, you need to make sure that your case has been properly restricted. Okay. In order to do this, most of you are going to go to the clerk's office where the case was prosecuted and just ask them to restrict the record. If your case was dismissed or it was a non-conviction and it happened 2016 or later, it should automatically be, actually, that's not true. It's 2013 or later. It should automatically be restricted. So if your case happened after July of 2013, you should just be able to go to the clerk and say, hey, you guys forgot, please restrict my case. All right. For those who have cases before July 2013, which is when the law changed, you may need to go to the police department and fill out an application. You can go to any police department, ideally the one that originally arrested you. They will charge you up to $50 for this. Usually it's around 25. And so you can, I would say first stop is the clerk. You want to ask, can I get my case restricted? If they say, oh, this was before 2013, you have to go to the police department to fill out a restriction application, then you can go there and fill it out. But for restriction for non-convictions, it's really more of an administrative process than a court process. A quick note about successful first offender and conditional discharge. If you've successfully completed your sentence and you got a discharge order, that case should be automatically restricted. You should not have to ask, regardless of when it happened. It should have been automatically restricted. Keep an ear out later in the presentation. We're going to talk about what happens if someone made a mistake and it didn't get automatically restricted. But for most folks, for first offender and conditional discharge, it should have automatically happened. Once the restriction is done, you can email us, our intake, to ask for a copy of a sample material to complete and submit a motion to seal to the court where the case was prosecuted. We can give you a sample motion. I think that's it. I'm going to pause in a second because there's a lot in this section, so I want to make sure we have time for questions. But one quick note about non-convictions. Many of you might have heard of the 7-year rule. I talked earlier, for convictions, they're going to be on your record forever till you have them restricted and sealed. For non-convictions, that's where the 7-year rule comes in. Under the Fair Credit Reporting Act, which we're going to talk about in a little bit more detail later, non-convictions can't be reported on private background checks for more than 7 years after your arrest. So that means if it's been more than 7 years since you were arrested and your case did not result in a conviction, that case can't show up on private background checks. All right. We always recommend doing a motion to seal in cases just to be safe and sure. But if your case is older than 7 years and it was dismissed or it resulted in a non-conviction, it's not lawful for a private background check to report it. And we're going to talk in a bit about how to advocate with those background checks to make sure it's not showing up. Do folks have questions about non-convictions? I think that was a lot of information. Or do you see anything flagging, Jalissa, that I should address? No is fine.
Not seeing any flag questions.
Great.
Yes.
Well, I'm sure we'll come back. Okay. So special issues. We want to flag some things we think warrant mention or that tend to come up a lot in our work. Dead dockets and correcting mistakes on your official GCIC. So my colleague likes to say, just because it's your official Georgia crime background check report doesn't mean it's accurate, right? Mistakes happen all the time. So we have some tips about how to handle this. Mistakes is going to come second, though. First, I'm going to talk about dead dockets. What the heck is a dead docket? A dead docket is a case that didn't get dismissed, but you also didn't plead guilty. It's like they put the case on a shelf. It's open, but it's not active, right? You don't have any court dates to come back. So they leave the case open. It's very frustrating that this is an option, right? Because it just leaves you in limbo. Maybe it was an option so that you didn't take a plea, right? You didn't want to have to take a plea and it just kind of lets time pass. But a dead docket and record clearing can get tricky. This is because there are a lot of different reasons that a case can be dead docketed. All right. It can be dead docketed as part of a negotiation that they say, you know what, we're not going to push this to trial. And we know you don't want to take a guilty plea, but we're also not going to dismiss the case. We're going to leave the case on hold, leave it open. It could be dead docketed because a witness went missing. And it could also be dead docketed for missing court because you got a bench warrant. Okay. So it's really important to figure out why was the case dead docketed, because different things can happen depending on why it was dead docketed. So the first step, I would recommend calling the court clerk where it happened, not going in person, because if it's a bench warrant, you don't want to just show up, right? So calling the court clerk to ask for a copy of the dead docket order before doing anything else. This dead docket order will usually tell you why the case was dead docketed to begin with. All right. So although dead docketed cases can be restricted and sealed after 12 months, we recommend you consult with a lawyer before you petition the court to have a dead docketed case restricted and sealed. If you're not able to do so, we just recommend that you proceed with care. Make sure you look at that dead docket order to know why it was dead docketed, especially if it was a very serious case. Contacting attorney is really the best bet here. It was part of a negotiated resolution. So if you know, for example, that your case was dead docketed because you did PTI, and then they just never dismissed the case like they were supposed to after you finished your PTI, that would be an example where it's pretty safe to reach out to request restriction and sealing on the case. I guess the only other thing to mention is that before you apply for a pardon, you have to resolve all dead dockets. So you cannot apply for a pardon with a dead docket on your record. They will kick the pardon application back. So if you're trying to get a pardon, just make sure, look through that GCIC, make sure you don't have any dead dockets on your record. Last but not least, GCIC corrections. So I like to say that GCIC is your official background check, not always accurate. Well, I don't, I'm actually stealing from a colleague, but on the left side of this slide are common issues we see, and on the right side are steps that you should take to resolve that issue. So the first mistake that we see a lot is that the case outcome or charges are listed incorrectly. This might mean your case is listed as a felony when it should have been a misdemeanor, or maybe just the wrong charge is listed. Obviously, if it's probably clear, but if it's listed as a misdemeanor, but it was really a felony, don't correct it, right? We don't proactively reach out to make those corrections. You don't have any legal obligation to correct your own GCIC. It's the state job to get it right. But if it's listed as a felony and it's really a misdemeanor, that's something you wanted to handle. So you want to call the court clerk where the case was prosecuted, ask to speak to their GCIC clerk, and ask them to fix the mistake in the system. All right. And again, kindness and persistence goes a long way here. Clerks can be very overworked. They can be grumpy, have a bad day, just like anybody else. Just be very kind and persistent. If the person who's talking to you says, I don't do that, or you can't do that, or something, ask to speak to a supervisor politely. The second error we often see is that you successfully completed first offender conditional discharge, but your case is showing up as a conviction or as a pending case. This is another one where it might be fixed to call the court clerk, but the other thing you might have to do in this case is actually call the probation office and ask probation to send that discharge order back to the court. Sometimes probation just doesn't do what they're supposed to do, doesn't send the discharge order. So I would, first start with the court clerk and say, hey, can I get this corrected? And if they say, it doesn't show on our end that you were successful, then I would go to probation and see if probation will send an updated discharge order. The last error that we see a lot is that your GCIC says time expired restriction rather than showing how the case was resolved. This means that the clerk's office never sent over the final disposition in the case resolution. Excuse me. So you want to make sure to call the clerk of court and ask them to enter the final disposition on your GCIC. So that, especially if the case was dismissed, right? It shows just like a pending aggravated assault, but actually the case resulted in a dismissal. You want to call the court clerk and say, hey, can you please enter the dismissal? Again, you catch more flies with honey when you're dealing with court clerks. Just patient, kind, don't lose your temper. They have a lot of power to help or not help you. Okay, so one question, will a sealed record show up on a private background check? The record has been sealed. Will it show up on a private background check? Let me know when we got some answers. What do folks think, Jalissa?
A lot of people are saying no.
Yay, that's correct. If the record has been sealed, it is not going to show up on a private background check. That is the final step in making sure it doesn't show up on a private background check. Okay, so I'm going to shift gears. We've been talking about all these background checks, but like, how do you know what's on there? Can you get a copy yourself? Hopefully some of you have already gotten a copy of your background check or you know, but if you're not sure, I want to walk through really quickly how to go get a copy of your background check. This is going to be important for two reasons. The first is just because you need to know what is on there so that you know what you need, right? But the second is that anybody who's going to be asking for help from Georgia Justice Project, you're going to need to get a copy of this. So remember, there's two kinds, right? And we know there's a Georgia Crime and Information Center report and private background checks. Let's see, I just want to look at my script and make sure I'm not missing anything. Yeah, okay. So first we're going to talk about your GCIC. We're going to start with your official Georgia Crime and Information Center report. Sometimes you might also have an FBI background check. The formatting is going to look different, but the content is going to be the same. So if you want to know what's going to show up on an FBI report for Georgia, obviously we can't, this doesn't include out of state, but if you know what's going to, want to know what's going to show up for Georgia, getting a copy of your GCIC is the way to go. So this relies on arrest records, and we recommend going to your nearest arresting agency and requesting a copy of your Purpose Code U. All right. There's a lot of different types of GCICs you can ask for. Employers see a Purpose Code E, right? So things that have been restricted are not going to show up. A Purpose Code U is unique to you. It's for your eyes only. You're the only person that can ask for it. And the reason you should ask for a U is that it's going to show you even cases that have been restricted and whether or not they've been properly restricted. All right. So you want to get a Purpose Code U. Because it's going to show things that have already been restricted, you don't ever want to show anyone else this record. All right. So if you get a Purpose Code U and then you're applying for a job and they say, can we see your GCIC? You're trying to save money. Do not show them that Purpose Code U because it may have stuff on there that has been time expired, restricted, that's, not going to show up on a Purpose Code E. Okay. So you're going to go to your nearest arresting agency, ask for a Purpose Code U. And I guess one note about warrants. If you think that you have an outstanding arrest warrant, don't walk into the police department. Okay. You would probably know if you did. If you have no reason to think that, then you're perfectly good. But I just wanted to flag it. If you think that you have a warrant out for your arrest, don't walk into a police department. You should reach out to the Georgia Justice Project. We may be able to get a copy for you. Or also you should call an attorney if you think you have a warrant because you don't want that hanging over your head. All right. How do you know what's on a private background? So that was GCIC. We told you how to go get one. How do you know what's on a private background check report? This is a lot more complicated because there are so many companies and it usually costs money. Some will give free copies, but many of them cost money and the different companies operate differently. It's really difficult to know like what all could possibly show up on a private background check private background check report. So our recommendation is to get a copy of final dispositions from the court where the case happened, especially if you know that that case is causing an issue. So if you have 20 convictions in Georgia and you already, you've gotten your GCIC, you see what's on there, there's really no reason necessarily to go get all 20 final dispositions unless there's a specific reason. But if you're not sure what's showing up for a particular case, like I know I got arrested 15 years ago, I'm looking at my GCIC, I see, this is showing up, but I don't know if it's right or it's not complete. Going to the local courthouse clerk and asking for a copy of the final disposition in that case is really going to be your best bet to know what is showing up on a private background check report because private background check reports rely on court records. So going to the court itself and asking for a copy of a final disposition is going to be what you're going to do. We have a red circle here that circles where it'll show you how the case resolved. An example is on the right. It's also a helpful document to get if you want to correct something in your GCIC. So if you've looked at your GCIC and it shows an outcome of a case and you're thinking, I don't think that's what happened. That's not what I remember. You're going to want to go to the clerk of court where that case happened and ask for a copy of your final disposition in the case. And if you get it and you're like, I was right, that disposition is going to help you have the conversation with the clerk to say, hey, this is not correct. Can you fix it on my GCIC report? So for those of you with longer records, you're going to want to get your GCIC first and use it as a guide. So your GCIC will show all the times you've been arrested. And although they're different, you can use it kind of when you're going around to the different courthouses to get the final dispositions. If that's something you need to do, you can look to give the arrest date. The GCIC will guide you about what information you need. This is what our intake staff does when we get copies of final dispositions. We get your GCIC first. Okay, I just will say I really encourage everybody, if you're at all interested in record clearing, to at least get your GCIC. It's just really the first step to know what's on your record. And even if you can't clear anything off your record, it's also going to let you know what other people are going to see, so that when you're thinking about telling your story, you'll know what you need to address, right? This is just a reference slide. We don't need to go through this, but it walks through each step-by-step guide, how to get your GCIC, how to go to court and get your final disposition. If maybe you can't find the case number you need, how to get that. Okay, this next section is really important, especially for folks who are wanting pardons, but really for everybody. For some of you, you've learned that you can clear your entire criminal record if you do these processes. For others, you've learned you can clear some, but not all of it. For a third group, maybe there are no options currently available to you under Georgia law, either because it's not possible or not enough time has passed. But regardless, you need to listen up in this section, because it's going to apply to everybody, no matter who you're talking to about your record: a potential employer, a future landlord, a licensing board, a criminal court judge, or the Georgia Board of Pardon and Paroles. Each of you is going to need to know how to tell your story. In my experience, this topic is near and dear to my heart. This is my favorite part of the work, because I actually believe we all have a story, myself included. And we don't always tell our own stories very well, right? We can be pretty harsh with ourselves, and that can cause us then to not be able to be persuasive when we're trying to get what we want from either the board or from the court or from a job. So how you talk about your criminal history, I think, is the single most important thing in determining whether you get the outcome you want: the job, the apartment, the license, the order to seal, or the pardon. Before we do that, I want to offer a disclaimer, okay? Dozens of people are on this call. Many of you have had different experiences with your cases. Maybe somebody pressured you to take a plea. Maybe you were treated differently because of the color of your skin. My observations are that racism is alive and well in our criminal legal system, okay? Maybe someone lied to you, or you didn't have the resources to hire an attorney to fight your case. Maybe you just needed to get out to get back to your kids. I know that the system is deeply flawed, to put it mildly, and we're here today offering the presentation because we believe you shouldn't be judged based on your record, all right? But what we're about to talk about, well, let me say it this way. Most of the time when you're telling your story here, it's because you need something. You're asking for something: a job, a home, a license, or your record cleared. And our experience tells us that it's not going to be helpful to you to try to convince people that the system or the other side mistreated you, right? So instead, we've found success in telling stories of redemption and rehabilitation, of trying to take responsibility in some way, in whatever way you can do so that feels truthful to you, in order to say it's worth taking a chance on me. All right. So what I'm about to say, I am not assuming that you did the thing that you pled to or that you were found guilty of. I'm not. But I just want to make sure that it's clear. We're saying this because we want you to get the outcome you want. And so if there's a way for you to tell your story with using the model we're going to provide, that's the way to try to do it. So first, before we talk about how to tell it, let's say when to share. When do you share your story? Just walk around telling everybody, right? No. Pardon applications and court petitions to restrict and seal, you will always tell your story. All right. So if you're trying to get a record clearing outcome, tell your story. Full stop. Storytelling is the heart and soul of record clearing work. How you tell your story is going to be the most important for that. Now, employment, housing, occupational licensing, meaning you're trying to get a license to be a nurse. You're trying to become a real estate agent. For these situations, the general rule is do not volunteer that you have a criminal record or tell your story, either on the application or in an interview, until you are asked directly. All right. Georgia employers can choose to ask or not ask about your history, and you don't want to over disclose. So if you're asked a question directly, you want to read the question really carefully, answer only the question that's being asked, right? So if someone says, have you ever been convicted of a felony in Georgia? I don't think anyone would do this, but you don't want to say, no, but I have a misdemeanor, right? It's only the question that's being asked. And also don't volunteer this information in an interview. All right. So interviews are a time to shine. They're a time to brag on yourself. They're a time to really sell yourself about all the skills you have and what you bring. If a lot of your life has been spent dealing with the criminal legal system, it can be tempting to come in kind of defensive, to want to talk about that, but that's actually not the place to do it. All right. So interviews and job applications, you want to be positive, focus on your skills and your accomplishments. Even if you're scared or it feels like your record has played a big role in your life, don't focus on it in an interview. Focus on your strengths. Okay. Sometimes you're asked though, right? And you're asked, and if you have to share, always tell your story. So you never want to say, yes, I have a record. Or, yes, I have a record. I'll talk about it at the interview. You want to prepare. You don't want to just check that box, right? Because then it's a big question mark. We know, you know better than I do, people care if you have a record, and that's going to matter. And so you need to be persuasive. If you're going to disclose it, don't say, we'll discuss later, prefer not to discuss. We'll talk in a minute about how to do it, but the general rule of thumb is that while you should never volunteer it, if you're asked directly and you have to share, use that as a chance to tell your story. If you don't, the conviction and the cases are going to tell their own story, right? This happens for me, or used to, as a defense attorney all the time. I see a record, I see 10 theft convictions and a simple battery conviction. There's a story I can tell about who that person is, right? When that person walks in the door, that's never who they are. It just never is. There's always some complexity to what happened. And if you don't tell the story, your record is going to tell it for you. Okay. So if you know, I think the last exception is if there's a case that keeps showing up and it shows up every time. Not you're wondering if it shows up, it might show up, but you know you've been offered jobs, you start working, and then they rescind the offer because of this case or cases. If you know it's going to show up, that might be the one exception. I still wouldn't lead with it in the interview, right? But when you get to the point in the process where they say, we're going to run a background check, that would be the one place where I would recommend maybe having something written or having a phone call with the hiring person to say, hey, I want to talk to you about something, and tell your story that way. Okay. How to share your story. The best redemption stories have three key ingredients: who you were then, who you are now, and some kind of turning point or aha moment where you realize that your life needed to change direction. All right. The boxes here offer a few examples to prompt you. I don't want you to rely on generic phrases like, I've changed a lot. Okay. That can be tempting, right? I'm a totally different person. You can say that, but you got to put meat on the bones. How do we know you're a totally different person? Okay. This doesn't mean you have to say a lot or lose all your privacy. It just means you need to cite concrete examples and evidence. So I give some examples here. Then, let's say you were young. The then piece, I think it can be really helpful to think about what was childhood like? How were things difficult for you? Was there one thing that happened that really threw you off course, right? Was it, so here, young, immature, lost, influenced by peers? Maybe it was poverty, just a complete lack of resources, housing, education, or money, not having healthy role models. Maybe it was a struggle with addiction or substance use. Maybe it was a struggle with mental health. Maybe it was trauma. So thinking about like, what was it that really got me into the situation that I got into? And then you want to talk about, was there an aha moment or turning point? This can take some time to reflect, right? Was there a turning point moment? Was there, you hit a birthday, I turned 30 and you're like, I'm done with this. I can't live this life anymore, right? Or you lost somebody, someone died in your life, or they left you because of the situation or the circumstances of your life, and that gave you perspective. Maybe there was a birth of a child. I hear this a lot, right? Children can be really perspective giving of like, suddenly I saw that I was the model for this little human, and I realized I want to be a different kind of model. Maybe you met a new partner, someone who inspired you to be a better version of yourself. Um, or maybe you left an unhealthy relationship. And then now, this part is you really can't brag on yourself enough. So education certificates, and especially focusing on the ones that happened after the cases that are at issue. Community involvement, neighborhood, church, mosque, school, volunteer work, social and personal stability. So you've had a partner, a spouse, children, chosen family. Not everybody has biological family, but that you're in relationships that are thriving and healthy, and references for your character, work ethic, and growth. References can be hugely important. So if you know that a case is going to show up over and over, having someone that you've worked for or a landlord, and think creatively here too. When you think about references, you want to think, if you lived with your cousin for 10 years and you paid rent to your cousin, you don't need to disclose that it's your cousin. Have them write you a letter. This person was a great tenant, right? It's true. So just think creatively about you worked for your uncle for a long time. All right, do's and don'ts. When you're telling your story, you should be vulnerable, honest, and brief. All right, you want to have a 2 to 4 sentence version of your story ready to offer. You're not going to be able to start with 2 or 4 sentences. None of us tells our story concisely. I'm not certainly not short-winded, but you want to kind of write it out and then whittle it down to about 2 to 4 sentences that you can have ready to say if somebody asks you directly. We'll give some examples on the next slide of what this can look like. Express regret if you can do so honestly. This could be regret about the circumstances that led to your arrest, right? If as much as you can express regret for, you should do that. If you can say, I regret my behavior, I think that's the most powerful thing to say. But if you can't say that, I regret the circumstances that led to my arrest. I learned a lot about not putting myself in situations like that ever again. Okay. State your desire to not be judged by your past mistakes. References, I said this again, I'll say this again, references, I can't overstate how helpful they are. Talk about what you're going to do in the future if you're given this opportunity. All right. So redirect the person of like, I'm going to be valuable to you. And that can include, look, if you give me this chance, I will be loyal because I know that you're taking a chance on me, and I'm gonna stay and I'm gonna do great work for you. Don't be afraid to say that. And emphasize the passage of time. So if it's been a lot of time, then you want to emphasize, it's been 10 years. And then if it has not, if you can't emphasize the passage of time, you want to emphasize why you've changed for good. Really put a lot of focus on that aha and turning point moment. What should you not do? I've already said it, but don't volunteer any criminal activity or cases that don't show up on your background. That's why it's really important to know what's on your background. Don't get into a lot of details about what happened in your cases. You really want to focus on you and how you've grown. And you don't want to say that you pled to something you didn't do. I know that happens, and a lot of people don't want to believe that happens. There's a lot of words on this slide. I'm actually not going to read through it, but it's giving you just examples of how to, like, for example, if a lot of time has passed, how to emphasize that, just some sample language that you'll have. When you're applying for jobs in housing, there are a few rights you should know about. I already mentioned the 7-year rule earlier in the presentation. This is part of a federal law called the Fair Credit Reporting Act. This act controls what you can and cannot have reported on a private background check, the ones that rely on court records. So if you believe that a background check company is reporting inaccurate information, reporting a sealed case, or reporting a non-conviction where it's been more than 7 years since your arrest, you have rights under this law. The first thing you want to do is contact the background check company directly and tell them that they have to correct or remove that case, whichever one applies. It helps to have a sealing order or a final disposition from the court when you do this. And they should do it because they know that it's the law. And lastly, you have some rights when you're applying to housing and employment. For example, employers cannot have blanket policies where they say, we don't hire anyone with a record. Most of the time, employers know this and they don't write it down somewhere. They're not going to say it like that. But if phrases like felons need not apply or anyone with a record need not apply. Those are not lawful statements. So if they're ever said like that, those really blanket statements, they must make an individual assessment of your record. And you can get more information about these rights at the bottom of this slide, but just want you to know that that's not allowed and there are some ways you can report it. So folks on probation, if you're on probation and you tuned out, tune back in. If you're on probation, listen up. I don't blame you, by the way, this is so much information. I probably would have tuned out of my own presentation. But if you've served 3 years already without any new arrests besides non-serious traffic offenses, you've paid all your restitution, if you had any, and you've had no revocations in the past 24 months, you are eligible under the law to have your probation terminated early. All right. So what are the criteria? That you've served 3 years already with no new arrests, you've paid all your restitution, and you've had no probation revocation. So that doesn't mean even if you were brought in front of the judge, maybe it was dismissed, right? If you had an actual revocation, then this doesn't apply. But if you've had no revocations in the last 24 months, you can apply for early termination. 2 important notes: probation fines and fees are different than restitution. So restitution is money owed to a victim. Many people don't have restitution that they owe in their case. If you've paid your restitution, but you still have outstanding fines and fees, you still qualify, okay? You can absolutely apply for early termination without having paid your fines and fees. Of course, you should attempt to pay your fines and fees, but you're still eligible to apply even if you haven't. Final note, non-reporting probation is still probation. So for example, let's see, you were on probation reporting for a long time. In the past 2 years, you're not even reporting. You're still on probation. And the reason that matters, or you may still be on probation, and the reason that matters is that your pardon clock doesn't start until after you finish your sentence. So if you're wanting a pardon and you're just, excuse the expression, chilling on non-reporting, you got to get off probation. So reach out to that probation office. If you don't know who your officer is, go to the office and say, hey, I'm eligible for early termination. I'd like to terminate my probation, even if you're on non-reporting, because you want to get that clock started. You can ask probation for a certificate of sentence completion, and that would be worth asking for. That's often helpful to show, for example, the Board of Pardon and Paroles when you ended your probation sentence. And driver's license suspensions. If you've missed traffic court or you're concerned about driver's license suspension and fees, you can maybe get a new court date and have your license reinstated with the fees waived. Okay, this is a law we helped to get passed. And it just means that if you miss court, you think the court may have suspended or is maybe about to suspend your license, call the traffic court directly as soon as possible. All right. There's a process you need to go through. There's a link at the bottom of this page. You can click if this applies to you. If you've just had your license suspended for missing traffic court, or if you just missed traffic court and you're afraid it's going to be suspended, we walk you through the process in more detail in the link here. Voting. This is near and dear to my heart. After becoming a lawyer, actually, I took a break for a little while to knock doors and register people to vote because it's a right that we all have. And I certainly don't force people to do it, but I want you to know you have the right. And unless you are currently serving a sentence on a felony conviction, your right to vote is intact. Okay. A lot of people believe that if they were convicted of a felony, that they lost their right to vote. That is not accurate. All right. The only people who do not have their right to vote are folks who are currently serving a sentence, probation, parole, prison, for an actual felony conviction. So who has their right to vote? If you're on a first offender sentence, your right to vote is intact. You can vote. If someone, maybe someone you love, is sitting in jail facing charges but haven't pled, right? They're not serving a sentence. Their right to vote is intact. They can vote. They can vote using an absentee ballot. So it's really, I think there's a lot of misinformation about this. So the one thing to know is that you do have to register if you lost the right for some period of time. So let's say you were convicted of a felony 5 years ago, you served a 2-year probation sentence. During that time, you couldn't vote, right? Once you finish with that probation sentence, your right is back. You've got your right to vote back, but you have to register. So you can do that on the Secretary of State website. We have information here linked, of course. Need additional help? We've got there are a lot of record clearing resources in Georgia. Some of them we help with. So we have second chance desks in Athens, Augusta, and Cobb County. I'm in Augusta. So if anyone's there, I might see you. I've worked in Cobb County for a while too. There's these second chance desks are great. They provide pro se support. So if you have cases in these counties, reach out to get information about how to sign up to participate in one of our pro se desks. There are also resources here for Savannah and Macon for other organizations. They're not through us, but they're still wonderful resources. And yeah, so, and then Metro Community Resources, these are just resources for housing and employment. There's a lot of links in here. Let's take some questions. Well, actually, do you want to explain? It's up to you, Jalissa, how you want to do this. Do you want to talk about how to apply to GJP first? Maybe questions first and then how to apply? I don't know.
I'm thinking maybe for the people who have to get off pretty soon,
Oh,
go ahead and
yep,
talk
that
about
makes
how to
sense.
apply, and then we can
That's
do the
great.
questions.
I
Okay,
love that.
great stuff.
So you can take it away with the how to apply to GJP. Oh, I got to go to the slide though, don't I? Thank you. Sorry about that.
Perfect. Thank you. Alrighty. Hi, everyone. I've been the person who have been answering your questions, or most of them that I could get to, and also putting in the links in the chat. But if you email intake@gjp.org, and you can see that email on the screen, I can send you a copy of the presentation slides so you can have all the links and all the information that you need. All right, so congratulations, you finished the first part of our application process, which is attending a First Friday presentation. So you can check that off of the checklist. So your next step is to email intake on Monday. So this coming up Monday, October 6th at 9 a.m. Emailing us at 9 a.m. is very important because we start looking at applications at 9 a.m. and looking at requests at 9 a.m. And so we answer those emails first. So if you're able to send an email, that would likely be best. But regardless of whether you're able to send it at 9 a.m. or later, you will get a response. But unfortunately, if you email us after that time, there's no guarantee that our applications capacity will not be filled. Okay, so you're going to email us Monday, October 6th at 9 a.m. Those who send in a complete application, and a complete application includes a complete GCIC Purpose Code U, which we have talked about in this presentation. But if you have any questions, again, feel free to email. So complete application, GCIC Purpose Code U, along with the application that we will send to you with your request for one. If you can get this in as soon as possible, a complete application. I want to reiterate this is your GCIC Purpose Code U and your application. If there are any barriers to you retrieving your GCIC Purpose Code U, please let that known in your request for an application, and we will be able to request that on your behalf. And the barrier includes financial, or if you are out of state, or if there's any other circumstances that prohibits you from getting this, please let us know, and we can be pretty lenient about helping you in that process. And here's another important part. So unfortunately our intake is going to be closed November and December, meaning we will not be accepting new applications in November and December. However, in the meantime, you can be requesting your GCIC and getting that so that when our applications do open back up on Monday, January 5th, you can request an application and get that submitted to us. Okay, so very important. Email us this Monday, October 6th at 9 a.m. to request your application. Please include your GCIC Purpose Code U in that request for an application. And those who will receive intake appointments will be notified. And you also be notified if our capacity has been hit. So yes, any questions, please email us at intake@gjp.org and I'll be able to get that information to you. Thank you.
And I just clicked to the next slide because we have it here, but it's just shows you the sample of what the top of a GCIC Purpose Code U looks like. We talked about that earlier in the presentation as well. And the sample GCIC request. Again, as Jalissa mentioned, a complete application includes your GCIC. So you can look at this slide and then the slides earlier that really walk you through the steps of how to get a GCIC. I saw a couple questions in here, just scrolling in the chat. I have not looked at the Q&A. My tech savvy is limited, but I've been looking in the chat. Jalissa, maybe you want to flag a couple. I see a couple that jump out to me. One of them was about working with children. So it is actually, it's a good question. For folks who are applying for jobs working with what I would call vulnerable populations. So children, the elderly, individuals with physical or mental disabilities. There are, if you get printed, so you're maybe going to work at a licensed facility, for example, you will do a fingerprint background check. And there are certain charges that will show up even if they have been restricted for those particular jobs. Okay. We couldn't get into every situation, right? But there are certain charges. I do want you to know they're very limited. Okay. So, for example, most misdemeanor charges will not be showing up if they've been restricted. But there are certain charges, sex charges, um, neglect or abuse of an elderly person. There's like very, very specific harm to a child, felony cases that involve harm to a child, that even if you get them restricted and sealed, that they're going to show up on a fingerprint background check for certain licensed facilities. So those are very specific scenarios, but I just want to flag that if you have a situation where you're wanting to work with vulnerable populations, that may be something that, if you have one of those kinds of cases, it's a concern. And then someone asked, how do you get a misdemeanor domestic family violence case sealed? Which is a really good question, because you heard me say that misdemeanor domestic violence cases are not eligible for misdemeanor restriction and sealing. It's difficult is the answer, but not impossible. Family violence cases, misdemeanor family violence cases are one of the options to apply for misdemeanor pardon. As I mentioned, most pardons are not granted for misdemeanors. They're mostly granted for felonies. So, but if you have a particular situation where this family violence battery case, misdemeanor, is causing a barrier, and you can provide documentation to the board, this is causing the problem, right? Or maybe even better, you have an employer that says, if this person can get this case cleared from their record, I will give them a job, or they will get the promotion. You have to just provide a lot of documentation for misdemeanors. Then a pardon might be your best bet to get the case pardoned and then have the record restricted and sealed. But again, for a pardon, you still have to wait that 5-year waiting period. Someone said, what is PTI, which I think we already talked about, but it's pretrial intervention. If you didn't get it, don't worry about it. You should know if you got it, and your final disposition will say it if you're not sure. Oh, Kimberly asked, it's a great question because I messed it up a little. For clarity, did you say that non-convictions are automatically restricted after 2013? Yes, they should be, right? But they're not always. So if you have a case after July of 2013 that was dismissed, or that's not a conviction, but that is still showing up on your fingerprint background check, you should go to the court clerk and say, hey, this case was dismissed. It should have been restricted. Please restrict it. That's in the presentation. Null pros just means not prosecuted, dismissed. What questions are you seeing, Jalissa, or did you see kind of thematically?
I saw a few questions regarding pending cases. So I think it'll be important to highlight our policy and those who have pending cases.
Yeah, unfortunately for pending cases, we don't do record clearing. That was in that initial what don't we do. But if you have a pending case, it frankly makes you ineligible for a lot of record clearing relief. And as a result, we don't represent folks, not because we don't care, but because they're usually unsuccessful. So our recommendation would be to focus on either getting representation for that case or fighting the case with the attorney that you have. And I want to just make a note here about public defenders. I am not here to defend public defenders by any means, but I do want to say, if you have a pending case and you have a public defender and you can't afford an attorney, or maybe this is the lawyer you have, work with them, push them. Because, and that could even include trying, reach out to their office, call them every week, be kind of like the court clerks, right? Be kind, but be persistent. It's your case, and you are the person who's going to care more than anybody else about that case. That can be true with private lawyers too, actually, right? And so I would just say it can be really easy to be hopeless and think, nobody cares, but you have to care. And so just keep going with that public defender. Say, what do you have? Do I have my discovery? Just push them, even if it's just, hey, it's me again, just checking back in. I really can't because the squeaky wheel really does get the grease. And I would say that if you are getting radio silence from a public defender, just no responses, that I would encourage politely going and asking to speak to a supervisor in the office. And you can request a change. You can also tell the judge that you would like to request a new attorney. So I just don't want people to feel like they're stuck. And that can be a really hard situation. And I think public defenders are like public school teachers, which is some of them are the best lawyers I've seen, and some of them should have retired a while ago, and some of them are there because they didn't get a job somewhere else, right? And so you just never know. You may also have a really good lawyer and want to give them a chance. But the one way that you know you won't get the help you need is if you throw your hands up and say, well, I have a public defender. So, it's like you got to stay engaged in the process, even if what you're getting back, if you feel like you should be getting more back, which you probably should. But I really encourage you to stay engaged in the process because that can make a big difference and ask to see the evidence. That was a did I answer the question? I think I did.
I've also noticed, oh, thank you, Cooper. But I've also noticed there was questions for people who successfully completed first offender. They're still having
Mm,
issues with their record being restricted but not sealed, and how to go about that.
yeah. So the sealing process, let me actually scroll back up in the presentation really quick because I think that sealing process for non-convictions, that's the process for first offender because first offender is not a conviction, right? So you're going to see this part for restriction. If actually, I'm going to flag two things in this presentation. This talks about you must file a petition with the court and that you can email intake to ask for a pro se motion to seal. So that's the first thing. If your case has been successfully restricted, but you just need to get it sealed, email intake and ask for a pro se motion to seal a first offender charge. That's the best move. But the other thing I want to flag is for those of you where it should have been restricted or you should have gotten a discharge, but you didn't, right? Look at the second line here, the orange. You successfully completed first offender conditional discharge, but GCIC is still showing a conviction. If you're at this stage, you want to go to probation and get a copy of that discharge order sent to the court. And again, this requires persistence, but you can absolutely do it. So if you don't have a discharge order, you need to go back to probation, get that discharge order, make sure the restriction gets entered by the clerk. And once that restriction is entered, that's when you're going to want to move forward with the pro se motion to seal with a court file. Anything else? I know we're almost exactly at 11:30, which is when this ends. I think
I believe you hit all the questions that I see in the Q&A.
someone asked for the link to apply. So I think with that warrants maybe I'm going to recap. And Jalissa, you jump in if anything I said was wrong is incorrect, but there isn't a link to apply. Okay. So if you're wanting to apply for GJP services, which again, a very small percentage of folks are going to be able to get it just because we're a small nonprofit. But if you are wanting to apply, you're going to need to send an email at 9 a.m. this coming Monday. What's the date? October 6th to the intake. I'm going to pull that slide up again. You'll get them in your email. But this is the process, okay? You're going to email intake on Monday at 9 a.m. And you're going to get an application back if you're one of, if you meet the cap, if you get your email in before we've reached our cap. And then you got to fill out that application as quickly as possible. And you also need to get a copy of your GCIC. So if folks are going to apply, the best thing you can do for the rest of today is get you to a police station and get a copy of your GCIC. That's really the best next step for you to take today. Jalissa, I don't know the answer to this question that B is asked. Well, I know that there is a cost. It's usually about $25. If that cost is a barrier, like if you're like, there's no way I can pay that, reach out to Jalissa at intake. But also the second one, do we still email if we haven't gotten our GCIC by Monday morning? What do you think, Jalissa?
So yes, it is still okay to request an application on Monday if you do not have your GCIC, because you still have to go through the process of filling out the application. But a complete application is one that includes your GCIC, Purpose Code U, and the completed application form. Also, I want to reiterate that our intake will be closed November and December. And on January 5th, Monday, January 5th, 2026, when our application for intake reopens, we are going to ask that you already have your GCIC Purpose Code U. So if you're applying, if you don't get an appointment on Monday, October 6th, then you reapply on January 5th, 2026, and please have that GCIC Purpose Code U attached in your request for an application.
I'm not looking at the Q&A. Would you mind just glancing at it, Jalissa? I think we're about ready to wrap up. I think someone asked about a child case. I'm guessing maybe that's a case involving child abuse or sex case or something like that. If the final hearing, I have no idea. I'm just making a huge assumption here. But after the final hearing, especially if it's not guilty, if you were found not guilty or the case was dismissed or not prosecuted, then you want to go through that non-conviction restriction and sealing process. But I would encourage you to go get a copy of your GCIC to make sure that that's actually what happened. A lot of times people get time served. They think that they were found not guilty. So I just want to make sure that you know where you are. You might be exactly right. You might have been found not guilty, but just confirm with your GCIC background check that that's what happened. Looks like folks are wanting the intake email in the chat, maybe. Oh, great question. Crystal asked, does the pro se petition need to be filed with the criminal court clerk or the civil court clerk? Criminal court clerk. Criminal court. You want to go, so it's some small towns only have a superior court. Many of them have a superior or a state court. So you want to look at where, if you get that GCIC, you want to look at where the case happened. Was it in superior or state court? Go to that clerk and file it there. Yeah. I want to say one last thing, which is I say this to all of my clients, but I also say, will employers still be able to see after getting? Thank you. I think these are specific enough. I think it's probably best if we just talk. If you just email us with your questions, because they're very specific. But I do want to say one last thing. This is a good, actually, no, one question. Just to be clear, you have to request a pardon for each state that you have a felony conviction. I saw that question earlier as well. Georgia Board and Pardons of Parole only handles Georgia cases. Okay, so if you can request a pardon for as many cases as you have, felony convictions as you have in Georgia. If you got a felony conviction out of state, there's maybe a pardon process for that state that's outside of the scope of this presentation. Okay, so you got to look and see what their pardon process is. I'm going to end with this. I have seen so many people be successful with criminal records. And I think I don't want to underplay how hard it is to move through this world, how much we label people and put stigma on people who have criminal records. It's so hard. I do this work because it's so deeply unfair the way we treat people with criminal histories, the way I'm so glad nobody's walking around with a list of every mistake I've ever made, right? And there's no reason that anyone here should have to do that too, or maybe even not a mistake, maybe something you didn't do, right? And I have people, there are business owners with multiple felony convictions. There are people who have found someone to employ them. Don't let no be the end of the road. You're going to get told no a lot, unfortunately. That's part of what's devastating, and it can really wear you down emotionally. And I just want you to know, just keep asking until you get a yes. And of course, record clearing will be one way to clear that path. But also for those of you who aren't eligible yet, just keep trying, because for 15 no's, you're going to get a yes at some point. Someone's going to give you a chance, and be creative. Small mom and pop businesses and stores can be a really great place to apply, or living with family if you're dealing with housing issues. But just, keep thinking outside the box, keep asking. So thank you everybody for making the time to come today, and we will send this presentation out so that you'll have it as a resource. Anything else from you, Jalissa?
Yes, I want to clarify, we don't have a list of everyone who is on the call. So if you email intake@gjp.org,
No.
I can get you a copy of the presentation as well as any of the documents you would like to request.
Oh, great. Thank you for that, Jalissa. I didn't know that. So shows I'm glad somebody's on top of that. So please email intake if you're wanting a copy of the presentation. All right. I think we're ready. Thanks so much. Take care, everybody.